Just to speak briefly to amendments 1, 2 and 3. I hate this, I hate trying to track them all. On number 1, it's already been said that it looks like we're effectively tearing up the Development Act by pushing this on scrapping environmental impact assessments and habitat directives. So at the very least, we need to be sure that this applies only to the existing suggested industrial power generation sites that are named here, and that there's no blank cheque given for the future. On number 2, in reference to the bill, that this is likely not to have a significant effect on another state. Well, we are meant to signal any bordering state that might be affected by pollution or environmental impact, etc. But to simply remove that is really just going too far. We're pushing a law too fast to track any development which would give a blank cheque in saying that it may not or won't not, is not likely to harm the environment anywhere else. So that's why we're opposed to that. And in number 3, on page 4, delete the words "or any other person." We have been told that this is being controlled and arranged by EirGrid, and the sites mentioned are operated respectively by SSE and DSB. And this suggests that it may be under EirGrid's control or another control, and it's too open-ended considering the groundbreaking nature of what we are giving in this Act, the rights being conferred on the Minister, on EirGrid and both the SSE to pursue a development which has torn up the Development Act and its various checks and balances. So we don't want a clause in it that is open-ended as this, as to who may control it and use these generations, and it's a step too far. That's all I have to say on them.
If I can, first of all, take Amendment 1, which I'm afraid I cannot accept. I understand that the deputies are concerned that the proposal may appear to be open-ended and as such could be used to approve other developments. But to be clear, what I'm asking the House to approve is the delivery of up to 450 megawatts of electricity generation for installation by next winter, and that is considered an exceptional case for the purposes of Article 2.4 of the EIA Directive, and that alternative assessments can be carried out by the state. The individual component developments, which themselves are the subject of a procurement procedure run by EirGrid on foot of the passing of the EirGrid Electricity and Turf Amendment Act earlier this year, will be the subject of a further assessment by Bord Pallola and approval by myself. So the Oireachtas is not approving any development or granting a development consent. There is an inextricable link between the preferred sites and the procurement process currently being concluded by EirGrid. Given that this legislation is passing through the Houses while that process is concluding, it's only prudent that we would ensure that it will not be necessary to go back to the House again with further emergency legislation in the event that an alternative site might be needed should that process not be concluded. What's important here is that we have sites available to accommodate this temporary generation, and that we can move on those sites in the quickest way possible. The removal of the reference to alternative appropriate sites would unnecessarily restrict the application of the processes provided for in this bill to the two named sites and would provide no backup options for the state. The sites brought forward will be the subject of further assessments and public consultation. What's critical here is time. I can't concede to an amendment that would tie the state's hand to the detriment of its citizens. I am satisfied that this approach is compliant with the EIA Directive and have sought the Attorney-General's advice in this regard during the preparation of the bill. Therefore, I cannot accept the amendment. If I could go through each beside briefly, but I think they deserve proper attention. I understand the intentions in each of the amendments, but in Amendment 2, again, I fear that the deputies may have misinterpreted the intention of the provision at subsection 3 of section 5. That provision has been inserted to confirm that no obligations arise in respect of transboundary impacts. In effect, in their proposal, the deputies are concluding that the designated development is not likely to have a significant effect in this or another state. It is in effect making conclusions in respect of the EIA. When it comes to the prospective sites, there are knowns and there are currently unknowns that should be assessed by the relevant competent authority. We know, given the site's location, that impacts on other member states are not likely, and consequently the transboundary requirements can be considered early and satisfied. With respect to effects internal to the state, we have provided for an assessment of those effects in the law as proposed. By replacing subsection 3 with the conclusion as to the significance of the impacts, the Oireachtas will be supplanting the role of Umbor Penola as provided for here, which in my view wouldn't be appropriate. I also want to be clear, I'm not saying that there will be significant environmental impacts to the receiving environment at these locations, rather that I wish that the relevant competent authority reviews the information presented to it and provides me with a reasoned opinion in advance of approving the proposed development. This is not an unreasonable ask, and I would ask the deputies to consider the effect of their amendment, if approved, on the approvals process. The formulation as proposed would not be appropriate, and I ask that they withdraw the amendment, and in the absence of that, as said, unfortunately, we can, on the government side, cannot accept it. With regard to Amendment 3, I appreciate again the deputy's intentions, but I cannot propose to accept it for reasons relating to flexibility and adaptability. It would seem to be unnecessarily limiting to restrict the applicant to a particular class of person. That said, as explained before, the sites are known, we know what needs to be done and where. While we have built some flexibility into the legislation, this isn't unlimited, and it is directly related to other processes being undertaken further to the aforementioned Airgrid Electricity and Turf Amendment Act 2022 and directions issued by CRU and myself. This is not a free-for-all. This is a target set of measures aimed at ensuring security of electricity supply for winter 23-24. It's limited in scale by reference to the 450 megawatt limited, and it is limited in location as there are only a very limited number of sites that can technically accommodate the proposal. The scope of any development to be carried out is limited also by Section 8, and I cannot therefore accept the amendment. Lastly, the Amendment 4 and 5 from Deputy Batchik, which kind of complement each other, put it that way, they relate to the insertion, as she says, of an additional Oireachtas approval between the assessment of Umbor Penola and the approval to be issued by the Minister. I will be proposing to reject these amendments as, in my view, it would add an unnecessary step in the process that could delay the commencement of on-site works. Amendment 4 requires the Minister to only approve the designated development further to an additional process set out in Amendment 5. That process requires the movement of a resolution in both houses of the Oireachtas with additional reports and conditionality over and above what is set out in the legislation. I reiterate that the purpose of the legislation being proposed is to remove unnecessary administrative steps so the relevant approvals can be issued as soon as may be possible. There is already a process available to the Minister of Government to approve a proposed development to address an emergency under Section 1812A of the Planning and Development Act 2000. I have done this already for development at the North Wall Power Generation Statement. What the Deputy is proposing goes beyond the existing provisions and would seem counterproductive that I would concede to such an amendment where time is of the essence. What I am proposing here is shorter than the process already on the statute book. I want to address some of the potential concerns of the Deputy. This proposed legislation requires me to arrange for an assessment of the proposed development in advance of approval. This goes beyond the strict requirements of the EI directive, where Member States are required to merely consider whether an alternative form of assessment will be appropriate. Therefore, an assessment will be carried out, albeit that it may happen in a phased manner, something that is suggested in the Commission guidance on this matter. Moreover, I have included provisions to comply with the Birds and Habitats Directive in order to ensure that Ireland complies with its obligations in those two directives. These are set out in Section 6. It is my intention to ensure that there is public consultation on these assessments, which will give some of the public scrutiny the Deputy wants. I would also draw the Deputy's attention to subsection 1 of Section 7, where I am required to take into account the assessments of the Board and any conditions recommended by it when approving the development, and it is my intention to do just that. In this regard, it would appear that not only does the Deputy's proposal add an unnecessary step into the process where time is of the essence, but it will also be a retrograde step in terms of powers already available to Minister and Government in the Planning Acts, and therefore I cannot accept the amendments. Thank you, Ms. Concurrent.